Well, hello. I hope you can hear me. If you can, knock on my door here. Uh, Jeff, Mark, or Jillian, just let me know you can hear me, and I'll start the fun. Oh, wow. I see what happened. Oh, boy. Aloha, everybody. Thank you. The voice of reason. If anybody has any comments or questions or any question whatsoever about what I do, again, let me just say it's not advice, it's activity of my brain to handle stuff. And hopefully you can incorporate into your hard charging warrior like mentality as we take on the bad guys. Nothing wrong with taking on the bad guys. Wow, nice showing. Um, if no one has anything to say, I can start and then maybe something will come. Um, this week we did something unusual, and I always start off my videos that are unusual to me. And the rationale behind that, Mark saying I'm the voice of reason, is who wants to listen to federal lawsuits? But don't you know, you put a cat into a video and suddenly everybody wants to. But the first videos were cat free. Thank you, Christopher Law, for your nice, kind words. What a great name, Christopher Law. I'll follow that guy. Whatever he has to say about the law. So cat video versus cat minus cat video. I got like 400 views in a day on federal lawsuit hacks. And you take a shot like that was as a result of someone saying, you're defending, do you ever sue anybody? And it's important to me that I eventually got to that video because it's important that if you're going to, unfortunately, there's only one way to win these things. And that one way is to be hard charging and a bully and make them think, frankly, it works for me. It doesn't have to work for you. I make them think I'm crazy and I'm not going to stop. And that doesn't have to be constant months on months. That may be just these days. How do I put this? I'm an older person. So, I've taken a lot of crap. So I can just get hit for hours and days and I'll just come back because I don't know any better. I got a thick skin, but I find younger attorneys coming up are more doing this than they are with their head up trying to look around and navigate things. So they lift 5 pounds. I lift 200 pounds. And so I've got the brain, muscle, and tolerance to just about handle any smack, any punch in my face. And I'll stupidly get up and ask for another one until I win. I'll just wear them out with my face, sort of like the rope-a-dope, the legal rope-a-dope of like Muhammad Ali, which at the end, he was suffering quite badly brain-wise because of the rope-a-dope. He just let them wear themselves out on his face. So I'm going to suffer at the end of my life with a lot of stress, health ailments. Right now, I'm freaking on fire. My brain is better than it's ever been. So here we go. Can you reference any case in the U.S. reference one's own in an answer, or you have to reference one's in your state only? Jillian, I kind of know where you're going with that, but can you be a little clearer about what your goal is, the question you want answered? I got it. I think what you're saying again is, and the answer is, the answer is everything for me lately, which is, it isn't use their own documents, but it's Green versus PRA. That is a Virginia case that you see me going on and on and on about and wanting you to use it, to read it, page a day, get out your highlighter, just go to where it concludes or it says in sum or we hold, and you'll get lots of stuff. But in the real answer to your question, Jillian, is It references several cases, Green versus PRA. So you could be in one of the 4 or 5 cases it talks about. And I'll repeat what I said before. Persuasive authority is a thing. It's actually in law school. You go, well, this isn't binding, meaning what you're referring to. If it's a case that you're referencing and it's in your state, then it is binding authority. So just for the purposes of making a point and nothing political, Roe versus Wade was overturned. It is now illegal to automatically have an abortion. It's state by state, but that's binding authority. You have to follow the Supreme Court cases. So in your state, there's a Supreme Court case, and in some cases, federal cases you have to follow. But if you have a really good case on your side, but it's from another state, look at how the court got to where its decision helped you. And if, like in PRA versus Green, they reference Wisconsin and Georgia and Ohio, well, you got something there. That's persuasive to the court that you're in. Number two, something is more persuasive if there isn't a case in your state on point. So you're actually doing everybody a favor by going, hey, our state hasn't talked about this particular issue, but in PRA versus Green, it was right on point, and the facts are the same here. That's a great question, Mary. I can't wait to answer that. So, yes, persuasive authority may be the straw that breaks the collector's camel back, because if the state's in a quandary about what to do, the judge, and you have this persuasive authority, by the way, it's more persuasive because it relies on Ohio, on Georgia, in Wisconsin, and there's a couple other states. So the court is going to go, well, Virginia is reaching out, so should I. And it's persuasive and it gives me a guideline. And you just emphasize the points that match your facts and then act accordingly. Mary's asking, can SSI, VA, or pensions be garnished legally? That's a great way that was framed, because just because you cannot touch somebody's federally excluded pension or Social Security doesn't mean debt collectors won't do it. So that's a great way of framing that. Then what you have is you have to go to court, get your money back by attacking the garnishment or whatever means they got to get your money. Now you got a case against them. And let's say them taking your money when it was protected. And I'm going to give you some great advice, by the way. Now you've got actual damages where you not only get statutory of $1,000 on the FDCPA, for example, if your credit scores got lower, or you bounce checks because they took money they shouldn't, yada, 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 that's actual damages. It's not immediate, and it's not the shield stopping it in the first place. But if that happens, you got great ways to go after them. So to your point, yes, generally SSI, VI pensions, a great example is OJ gets away, if you believe he got away. I'm not saying I do or don't. I'm just saying he got away. So they went after him civilly. Ron Goldman gets $35 million judgment against him. OJ's in Las Vegas. He moves his domicile to Florida, where you're protected. And the only income he had was a pension from the NFL of $25,000 a month. And that's why he moved to Florida, because not only does Florida stop collections, but your pension is protected. He maybe double dipped as far as the pension protection. So that's the answer to that. So here's my advice. If anyone listening has an account that has funds from a pension, Social Security, or federally protected exempt, they call it, in garnishment terms, collection terms, it's called exempt income. If anybody has that, then create a bank account or with the one you currently have and call it Social Security bank account, pension bank account, federally exempt bank account. Because now, when a debt collector, getting back to your point, Mary, illegally tries to take your funds from a federally protected exempt, the word is exempt, funds, they can't say they were on notice because you've named the account that they're attempting to subpoena and follow up with the garnishment. Social Security account. They won't touch it. They'll run from that. They're very cognizant of that. So the other side of that is do not commingle funds, even a dollar, with those federally protected funds because they lose their immunity at a minimum to the amount that you put in there. But then you have to ferret out how much was not pension, how much was pension. So that's actually a warning to you if you think about it. If you put on your account Social Security, you won't mingle other funds inside of that account. It's actually telling you. So everybody's on notice, including you, because we all make mistakes. So that's the answer to that. Don't commingle and you don't lose the immunity. It's look at it this way. Superman is strong, but if you add kryptonite to Superman, he's just a human being, even weaker than that. So any money that's not federally protected that goes in there is kryptonite to your Superman funds. Hope that explains it. If Jillian Kidd says, if one answered all 4 lawsuits with a counter affidavit within the time allotted and the law firm suing only responds to one of the counter affidavits, are the other 3 defaulted on? If you have any doubt, shout it out. Get those counter affidavits filed. If you have a counter affidavit, have it reference the case that it is countering. So you got 4 lawsuits, and I do it all the time. I'm happy if you don't need me to do this, but I'll go, Mr. and Mrs. Smith are being sued, Jones v. Smith, Jones v. Smith, LAV and v. Funding v. Smith, if it's the same law firm, same filing. So just name the cases inside the affidavit. And you might even say in the affidavit, this affidavit is in response to all 4 cases named above. You've got the case number, you've got the name, the nomenclature. So that's how I would do that. And that's how I've done that. I have regularly have, especially with student loan, NCSLT, National Collegiate Student Loan Trust, I'll get clients coming with 4 or 5 lawsuits. So as long as your affidavit reference what it is you want to counter, you're a winner. You're a winner. So get your affidavit corrected, amend whatever you have to amend, and file ASAP. I hope that answers your question, Jillian. And I was never been into radio myself, although I make this joke. I have a face for radio. But I understand the concept of dead air now, so I'm not going to let that happen. As I was saying, I was doing these federal lawsuits, and it's amazing the response that people wanted to hear about federal lawsuits and why and how. And the main thing that I wanted to impart to you that sounds to me technical, but I find people that are listening and following this stuff are quite adept and smart about this, while I put myself down thinking I'm not doing a good job. So I will tell you that the main thing I want to impart to you is that Article 3 standing. When a president put 3 Supreme Court new justices on the Supreme Court, they had a mandate to be anti-consumer, among other things, anti-abortion, pro this, pro that. It's all right. It's all good. It all works out in democracies. And they were anti-consumer. So they brought in this new standard. There was a case called Spokio from 2016. And it was a fellow that had his private information, not much, put in a Spokio designation for all to review as far as and using his credit report among millions of people's credit reports. And the court came out because these FDCPA cases and FCRA cases were getting settled and attorneys getting rich filing class actions for a statutory violation. I don't know if it's very possible that the Supreme Court justices got that mandate to cut that stuff down and make the funnel smaller. And it did what it should have done, which is stop bullshit cases getting filed that aren't helping you because they're weakening the cases, and they're not helping me because attorneys are looked upon as just trying to make money rather than helping people with these consumer cases. So they made it harder to file by doing what's called an Article 3 analysis. And later on in 2022, after Spokio from 2016, they went really nuts and said, you better have actual damages, which goes against the law that Congress created, which was if you show any violation, and that's why you only get $1,000, you get $1,000 in your attorney fees and costs. It enables access to courts that consumers that are in that bad situation normally couldn't afford an attorney. So they're also cutting people from being able to obtain attorneys. And then there's another part to the FDCP. It says you can win on statutory or you can win on actual damages. With the statutory, just to show the statutory violation occurred, you win. And I would have hundreds of those cases, and they would be over in 30 days in a federal court. Or the other case under the FDCPA is actual damages. You can go and file because you lost a job because of frequency of calls from a debt collector. You were making $800 a week times 10, because that's when you got a new job. It's $8,000. You proved actual damages lost as a result of the injury causing behavior of the debt collector. Now, statutory damages are really rare to win. They throw you out of court. They say you haven't met Article 3 standing, even though Congress passed a law saying this is all you need. So what's happened is, the beauty of our wonderful system is we have 3 branches, executive, judicial, and the other one, no, the Congress. They can't impinge upon each other's power. And that's the beauty of our system. It's called, no, not your own documents, checks and balances. So when the Supreme Court went into the Congress's purview by saying, yeah, you wrote that, but nah, we're not going to follow that. In fact, we're going to change it. That's where you go to overcome a congressional bad idea. So the Supreme Court was bootstrapping on judicial review powers. It's allowed to change if it's not illegal, or arbitrary. Now the Supreme Court has got to come in and tell them to go fix it. But what a Supreme Court is supposed to say is the legislators got to fix this, or they should do this. They were just acting, and here's the rub, like legislators when they changed the law. And that's not a check and balance. They just usurped and took another's power. And that's why we worry about authoritarian power. We sometimes don't like our presidents, but our system is fantastic. So if a president gets out of hand, Supreme Court, Congress, the War Powers Act. Here you go, president, go into Vietnam. He abused the hell out of it. Congress makes some changes. Hey, here you go, president. Under the War Powers Act, you can go in Iraq. He did. He went too far. Congress made changes. And that's how the system's supposed to work. Congress gives the president his power. In state versus federal, there's the 14th Amendment. Federal can impose on a state law or judgment. Getting back to Mary's question, you can't go to federal court and go, hey, they got a judgment against me. Can you overturn that? No. The 14th Amendment doesn't allow you to do that. So there's the check and balance and respect. I used to do hundreds of these FDCPA cases where I'm suing all the time, and they were looked upon as silly consumer jokes. And here I am in the middle of a court arguing the supremacy clause against the 14th Amendment and the federal supremacy clause to go in and chip up. And in my head, I'm going, you didn't sign up for this. You're not that smart to argue constitutional law. What are you doing? The voice was in my head. I went to this work because I could be good at it. I could be a big frog in a small pond. I've since got a little bit more respect for myself, a lot smarter, I think. And I already had it. I just put myself down. But I couldn't believe, as consumer attorneys, we were put down constantly. You know what the number one lawsuit that's filed in America besides PI? You got it. Debt collection against people and debt defense and debt lawsuits. We're suddenly the PI attorneys of collection of debt of lawsuit filings. And there's the respect. You can see that a lot of cases now are going to the Supreme Court that are FDCPA related. If we get some data, I'm going to tell you some cool stuff. But we don't, because Mary's asking, can you commingle exempt monies? That's a freaking great question. Like PA pay with pension. Belt suspenders, I'd make 2 accounts. Why do you need to even take the chance? But yeah, you can, because they both offer the same exempt. Does it make Superman stronger? Superman doesn't need to be any stronger. It has a federal exemption. But the greater likelihood that you're going to screw up should be eliminated in your golden years. So have 2 accounts, is my answer. I answered one of my lawsuits from Mark asked from Midland Credit Management back in December 29, 23. Excuse me. I have not heard anything from the court or wow. I'll read the thing to you. I answered one of my lawsuits from Midland Credit Management in 2023, December 29th. I have not heard anything from the court or the opposing counsel. It shows online the case is open. And my answer is C. Make sure the answer was received by opposing counsel. So you should have a proof of service that says that, and that will appear depending on the technological prowess of your county website. Proof of service. In fact, that's what I would do right now. Create a proof of service that says I served MCM and I served their brother or sister counsel. If you want to, you may be putting your hand into a nice hive seeking honey, protecting yourself, and then you're going to get stung because someone's going to wake up to what's going on. So I would protect that court file so that if anybody wants to mess around, that you are protected. So a proof of service saying you did what I hope you did would be the elixir to that problem. Or if you're sure that you did everything right, don't let sleeping MCM dogs lie. If I could explain to you how lawyers and their clients are sometimes so separated. In a case with MCM, they've got millions of cases and the attorneys can't keep up with them. MCM is going through a change now, and law firms, at least in the states that I practice in, aren't happy about this. They're taking cases away from the third party attorneys, and MCM is going more in-house. For you and for me, that's good, because now you don't have some jerky attorney trying to make a living off your victimization. MCM will make a deal with you. Those attorneys, they get there at 9, they come out at 5, they'll make a deal with you. Whereas a attorney that's been hired by MCM, like in your situation, they're going to try and make money off the file and be jerks about it. They won't have the big picture. And that's another reason why MCM, I think, is taking back all its cases, because at the end of the day, they aren't worth the fight and the bills that MCM is now paying. Mark says, I did send it out and do have a proof of tracking. Proof of service that it was served is the key. They did send me an unsolicited validation that I posted on the community. Make sure, obviously, you've kept it and line it up. If you've sent the proof of service to the court, then you're good. You're golden. If you want to add more to that I'm missing, but proof of service is key. With that said, folks, I'm glad that Mark is bringing this up. But it's so cool about how you folks trigger me in a positive way. And hey, you know what? This is what I want to do next week. I want to film videos that say, how do you do a proof of service? And then I can have tons of proofs of service. My Uscreen thing that I use to do this work, I don't know how long I'm going to stay with them, but I want to hang in there with them. You have to do a video to get all the paperwork that I want to get people, which is okay. I'll just do a minute going, what is a proof of service? Here's why it's important. Here's how to do it. And then have a ton attached. As long as I do a video, I can attach tons of stuff. How do I talk to an attorney by email? I'm going to give you a quick explanation and give you examples so you can use in regular events, like when you're sending an attorney your responsive pleadings. Here's the way you should say it, and here's an offer you should make. And then I'll go how to answer, or what to do when something shows up. So if you want a video, and my editor said, why don't you do a video of A to Z? Like, here's the lawsuit. Here's everything that should be done or could be done. Boom, to the end. That may be too much, but I'm listening if anybody has any thoughts. And if you want to do it out of your own needs, just tell me and I'll do it. So if you want me to do a video on the process of A to Z, I would prefer to do a quick video, because I can do more of them, and then give you choices. A quick video. What do I do with an envelope? Dumb question. No. You take that envelope and you take as many copies as you can and store it somewhere, because envelopes save your butt. They literally have the post office proof of service. So that's an example. All the 30 years of tricks and things that I've done. What does waiting in the weeds mean? It means you're ready to pounce, but you're waiting in the weeds. That may be a video. Here's an example where I did that. I want my other side to supplement discovery. And I just did that. And I think I attached a letter, but I may just do a video, how to write a letter on supplementing discovery, because you've got to tell them certain things as, I lose it when I'm on pressure, but not a term of art. So you've got to say, hey, your questions were invasive, non-responses, or just plain ignored. Well, that's a trigger that they broke the rules of discovery. So I thought, hey, I'll have a bunch of letters that people can use for their state. So if you want to give me a list, or however you want to give it, you're helping me help you. Because, I thought also, this is boring, but I thought of doing a video of the layman's law library. So A, affidavit. A, answer. What's an affidavit? 5 minutes. What's an answer? 5 minutes. I was thinking of doing something like that. If that's too much, but you don't have to sit there from A to Z. You can go, shoot, I gotta get what's a deposition? Or I'll tell you what a deposition is. And then I'll have a list of notices of deposition and deposition questions. So this is what happens to my brain. I sit in bed of the 6 hours that I barely sleep and go, video this, and I'm forgetting that I have a day job. So I'm working constantly. Look at this face. Okay, now let me just go back to not talking. How do I send a proof of service? Great idea. What would be amazing? Thank you for all you do. I feel like I passed the bar listening to you. I wish I've had ex-girlfriends I need you to talk to and tell them how great I am, especially this last relationship I was in. I've never been crushed by someone that's 5 feet tall and she should have been an attorney. Killed me. And to hear these wonderful things, it's nice for you to say these things. Thank you. I'm still But I'm now with a wonderful girl that I feel like I deserved after the hell I went through with, and she's the best. It's like my first ever girlfriend. She's so good. I hope she's not watching. Christopher Law, almost having a literal chessboard to see the most common strategies used against people. How you play the game makes sense. Yeah, I love that's the weeds. Wait, and then jump. My answer had the proof of service, by the way, that is the one that says who I sent it out to. Yes. So this isn't in any way yelling at you or saying anything bad about you, Mark. Thank you because you're really participating. That's why I should do a proof of service because of your question mark. And also provide it for you so there's no question because I hate doubt. You know, you do something and you're like, oh. So if I can eliminate that most human of pains in the butt, doubt, did I do it right? I feel like I've succeeded in some respects. So I'm going to do this. You've given me good feedback. Jeff Bow, yo, it would be nice to know how a non-attorney can search for cases without having access to Westlaw or NCLC. All right, I'm going to tell you how this attorney researches. You ready? Drum roll, please. There is no drum roll. There's no editing. I'm just going to literally tell Cindy, run it, and we just upload it. So hopefully there's no fart noises or dogs barking, no cats. Oh, did everybody like the cats? Anyway, the answer to your question, Jeff, is that you're going to do it the way I do it, and it's already been done. Google it, because you don't need, and it's unfortunate, but this is the nature of technological prowess. I'm using that word again, of our internet, of our lives, of the way our brain is really fast. That's what the Google is. It's reacting. People talk about AI and all that stuff, but it's just keeping up with your brain. You're way ahead of AI. Trust me. Don't be scared of it. It's catching up to you because your brain is fast. So Google is catching up. So go to Google Scholar. If you know the name of the case or a case in the field that you're looking at, and I hope I'm not boring people what they already know, but you go to Google Scholar, pull up the case, and it'll say how cited. 2 good reasons why that's good. It'll tell you if it's been overturned. It'll also tell you other cases that are either saying, nah, that's a dumb case, or yeah, that's a great case. And the Smith v. Jones cases relies upon your case. And you go in front of the judge. Not only is this a good case, Your Honor, but Smith v. Jones says this is a great case, and you'd be a moron not to follow it, Your Honor. Leave out the part moron. So that's hopefully answered your question. Do you use Google? Oh, there you go. Jeff's on top of it. Scala is the way to go, but Google is the same thing, really. So why do we need anything? How do you get unpublished cases? There is no delineation. There's no difference. If you look, when you pull up a case, you should go do it right now if you want. Go to Google Scholar. Let me give you a case that you can do that with right now. And I'll show you exactly what I mean. Okay? Dead air. I know. Hang in there. Go look at case Brown Bark 2 versus LP versus Bay Area Floor Covering and Design, Inc. et al. It's a Michigan Court of Appeals case. You can just put that in because that's how we search. And what'll happen is it'll pull up the case and it'll say, you ready to answer your question about published? Unpublished. And if there's a cited case that was published, that makes your unpublished case, by the way, bootstrappingly better because the published case. So that's a good way to get an unpublished case. Respect by just pull up Brown Bark versus Bay Area Floor Covering. It'll say unpublished, and then it'll say cite and see if it goes to a published. So I think published versus unpublished is the biggest line of bullshit. because unpublished cases in an area, and this is in my area, where there aren't published cases, are published cases. They're more than persuasive. Yet I'll hear a debt collector attorney go, "Yeah, Your Honor, it's unpublished." So I'll go, "Oh, do you have something that is published that's better than this?" Counselor, blah blah blah. So that my point is, it's the only game in town. So the judge, and by the way, when a debt collector says it's unpublished, it's like saying he's unshowered, but he's a human being. It has relevance. It's still purposeful, and the court can still look at it. Unpublished doesn't mean unread. It just means it's not published or completely binding where it doesn't need further support. Even published cases, by the way, can get trumped if it's in a federal area saying, no, I don't think so, even though they say that in the federal court of wins. And again, you have the supremacy clause and 14th Amendment, yada, yada. But the difference between published and unpublished is UN in my eyes. It's just because unpublished as opposed to what? Published? Like in the Brown Bar case, there are no published cases that's talking about. A court that ignores that is bullshitting you, because in at least in Michigan and most states, by the way, there just aren't strong cases saying, yeah, debt collectors, you were right to sue without proof and lied and misrepresented and messed up the credit report. So most cases are pro plaintiff, pro consumer, sorry. So where's the unpublished or published case saying, no, Brown Bark is wrong because it's unpublished? It isn't. It's a lot like, this is another thing that drives me crazy, and you're going to start getting this if you're in this area. They want to bring something in. Most, if not all, paperwork, or what's the definition of hearsay? An out-of-court statement offered to prove the truth of the matter asserted. All right, so everything is hearsay because you're having to bring stuff in. The guy's coming in to confirm hearsay, but you meet an exception. There's actually a cool exception. The present sense exception, dead man's exception. He's dying and he said something, Bob did it. That's hearsay. An out-of-court statement. It was made out of court, not during the court. He wasn't dying on the stand. And we go, sorry, hearsay. But the exception is, it's called dying declaration acceptance. It is thought, because hearsay is all about reliability. How credible or reliable should we depend on the source of the information? And a man, and this may be archaic, but a man or woman, sorry, I like dead women too. Oh, that's horrible. Dead man, he or they or she or whatever. If they are dying and they say something, it is thought that is credible because on your deathbed, you're unlikely to spin a tale or lie. But you may hate Bob and you want him to go down, and you know you're not going to get called on it because you're going to be dead. But that's an exception to hearsay, dying man declaration. It's not man, by the way. Sorry about that. It's dying declaration. So the big thing that you have to watch out for is 8036, whatever your state is, the business records exception. It is a mess. It is all based on a judge's laziness to interpret an exception. A case is an exception. It therefore is less than unpublished, less than blah, blah, blah. My point being, for something to be an exception, it's 1 in 100. And yet you're going to see businesses bringing in their out-of-court statement offered to prove the truth of the matter asserted under the business records exception. And most judges are wrong about it. It's an exception. So if you have 100 cases like I regularly have, I should only see one of those cases being used under the 803.6 exception. No, judges are lazy and they're going to let stuff in rather than fight about it in a hearing. It's life. So everything is hearsay. Act accordingly. Not to beat a dead horse, but at my previous question, do I sit and wait out and file a certain motion? Mark, thank you. I answered the question. I'm not being terse with you, but let sleeping dogs lie. I know you want resolution. And if you do, I'm going to tell you the truth of what happens. Attorneys that are on that case don't give it any thought. If it goes away, they'll do them a big favor. They're hoping it gets dismissed. They don't like opposition, educated opposition, so they just don't deal with it. They're really, I think, waiting for the court. A court in its docket will dismiss cases without asking. They'll go, hey, we're going to dismiss this case in 60 days if you don't do something. I guarantee you that's what those MCM attorneys are doing. They are just saying, it'll just go away. And so a order to show cause will come in. That's one reference saying, parties, are you doing anything about this? Because we're going to dismiss it with prejudice if you don't. And I think that's what they're waiting on. You may find that the attorneys that have the MCM case no longer do. I would go see, and they're not going to help MCM when they just rip the account away from them. Remember what I said at the beginning? Got to find my bottle top. Remember what I said at the beginning? Hi. That the MCM is taking cases away from attorneys. I bet that's one of them. And they've said, well, screw it. I'm not going to do any work on this file. And they've just let it go. I bet you. Happens all the time. So if you make some noise, people may rise up. So you've got to, I'm not going to answer the question for you. I'm answering the question for you. I would let sleeping dogs lie. Why start something? Because then MCM may assign its own attorney. Oh, we got to get on top of this. We got to go beat this guy. Blah, 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 blah. Unlikely. This case is going to go away. And on a side note, if it goes to a dismissal with prejudice, case is automatically obviously gone. Never again. The debt is eliminated. It can't be sued upon again. And if it's still in a credit report, use the dismissal with prejudice that will be automatically kicked out. Is the other way of doing this. I'm going to give you informed decision. You can do a quick motion for a status conference. Or you can just call up the court and the clerk and go, hey, what's going on with this case? And what'll happen in is like, oh my God, we should have sent out the show cause notice. So maybe that's an easy way to do it, but you're still having the bees wake up as you're eating the honey. So I hope I'm answering your question with other options. Yes? Capiche? Mary asks, credit card statements considered acceptable validation when dealing with credit reported collection accounts. I'm going to need you to give me more. If you're saying you sought validation and they sent you credit card statements, total BS. Because if you look on the FDCPA 1692G A1, it tells you exactly how they're supposed to give you certain things, including the original creditor. They may be going, well, it says right on the statement, Synchrony Bank. No, there's a great case that I rely upon all the time. Of course, it's gone. That requires. I'm going to try and do two things at once here. I'm going to give you the case to answer your. If you allow me to type, so I can help you all here. Validation. Sorry, this is dead air. Come on, baby. There it is. All right. There's a great Sixth Circuit case, and you may go to other places. It's called Haddad versus Alexander Zelmansky. I just want to take the. How can I do this? I'm going to write it. How's that? I'm going to write it. If you don't mind me typing. That makes sense. Big dummy that I am. I wonder if I can still do that. Nope. Nope. Okay, I'm going to have to type. Great TV. Oh, now the thing. I'm not being a good guy here. All right. Haddad versus Alexandra. I put it in. It's a Sixth Circuit 2014 case, which says you're required to cease and desist from collecting upon the debt, including contacting a debtor's credit, until you properly validate and verify the debt amount. So sending statements is with no directions. By the way, the court in that case went to the work of going, how about pointing to something where you're pointing out why he doesn't owe this or not? In that case, they said he owed $75, and they kept saying he hadn't paid enough. Essentially, forgive me if I'm messing the facts up. And it was like over $50. There was $50, which they refused to show and give him the right. And the court said, wait a minute. If you're going to validate, the standard of care has to rise. You've got to do this. You've got to do this. You've got to do this. So just sending you a bunch of BS statements is so clearly debt collector-ish. So now they can keep pursuing you. I would immediately send them another validation cease and desist letter that says, I'm in receipt of your response. You just sent me a bunch of statements. And just remember, a judge or a jury may be reading this. Could you please tell me under the 1692G who the original creditor is, when they assigned it? Ask about securitization. Do you have the credit agreement? Do you have something with my signature? All that, and go, and this is why you're doing this. At the end, you go, and of course, under 1692GB, you must cease and desist until you properly validate, which you haven't done. And there may be a case in your district similar to the Sixth Circuit Haddad versus Alexandra case that you can cite there. But you now have something in writing where you said, hey, you didn't. So to go to court and go, hey, you didn't have something in writing, because that is going to be your friend. And again, Parker's rule, who cares if they don't respond? In the PR versus Green case, the court made a point. Not only did you not this, but Miss Green asked you just to validate, and you didn't do it. If they don't, check it out. You got a good case. If you send for that proper validation, and read Haddad, it'll tell you, you need to do this, you need to do this, and they don't. And you even maybe reference Haddad so that the court is now looking at sort of a case that supports what you're saying in a simple letter. Lawyers should know you're a non-attorney, so you're doing all the right things. And then they contact your credit by saying that by pulling it or do some collection activity, you got a great case saying you violated the FDCPA's cease and desist rule. Oh, you contacted my credit after I asked you to validate. Always check those dates of when they pull your credit. It'll say date of recent opening or something. That's pulling the credit date. And if you sent this letter, certified return receipt requested, leave a paper trail, registered by mail, you have a good case, a strong defense, and a judge on your side. They just want to see a snapshot of what really happened. They don't want to hear paperwork. As I said in one of my last videos, demonstrative evidence. Demonstrate. the door-to-door salesman with the vacuum cleaners back in the day. He would throw a bunch of dirt on the ground and then suck it up, and they're demonstrating this thing works. I'm not, because even today we order off Amazon. We go, oh, this thing does what they said it did. And you can look at pictures and videos, but demonstrative evidence where you can actually see it picking up the stuff. So be kind to your case and send that letter out. If you contact me specifically, I don't know if I can do it tonight. I got 10 million things. I'll just write the letter for you. What a dummy I am, right? I'll write the letter for you and send it to you if you email me. Next. In reference to marriage question, I believe the statement is being provided. Yeah, it's got to say that. Yeah, it's got to say who the original creditor is. Yeah, it's got to be specific about assignments. There's this new stuff coming out, and I've talked about it before, called fintech. And you're going to see more and more of it because the economy is going to be a little weird. And so it's 14% loans, personal loans. And what it is a bunch of bondholders put together a nice trust with tons of money. Then they give it out to banks, fin banks, and other people that know states in the United States that are more flexible on usury laws. That's why you see a lot of these cases coming out of Utah or New Jersey. Like, look at velocity cases. Look at the underlying loan agreement. It'll be New Jersey law or Utah law, and that just kills them too. But so they immediately get the money, then it's already securitized. They securitize it back. It's the biggest mess going for debt collectors that buy this debt. It's been messed with and chopped up and sliced and diced. It's great for you. They can't prove a thing. But so they're operating to get money quick to people. They securitize the hell out of it. It gets diced and sliced. And then it's sold as being sold. And again, this is so true. When you see the word account in the lawsuit, when they could just as easily use the word debt, why not use dishwasher or scissors? Why not use debt? Why is the debt word not there? They're treating it like a 4-letter word. Big dummy that I am. Somebody's calling me beautiful. You obviously don't have video. Copy and paste, says Philip. Philip is a new member. Welcome, Philip. If you all want to tell me what you do, maybe I can answer questions better. It's up to you. And then I shape my answer to you. Oh, someone needs a beer here. Oh my God, Christopher Law can read minds. Mary said, oh, snap. Mary said, nice. I like these people. I play a lot of pickleball. And when I moved to an area on my own after a divorce, I'm a mess, right? I had no friends, no contacts. I just knew very personally, I got 20 years left. That's what I have in my head. So I want to work hard and play hard. I want to play harder than I work, and I work hard, right? So I need to make friends and girlfriends and whatever. You know what the biggest matchmaking possibility for friends or for relationships? I swear. Pickleball. You can be playing a Trump and Biden person, and that one's wearing Trump America and Biden blue, and they walk in, they are friends. I swear. I'm Jewish. You can be strong Christian. We'll have a blast. And it's within the pickleball situation, all the nets. And I swear, I've traveled a lot and played a lot of pickleball. I have a tournament next week. It's the biggest collection of nice people. I went to this tournament once, and one guy was a real jerk. The Twitters that everybody was texting, Bob's a jerk, but because it's so unusual to have a jerk. So it's a great way to meet people and have friends that are all interested in the same thing. Like, here's where I'm bringing this home. Just like here, I've noticed where you have a similar need, you just attract nice people. Pickleball attracts nice people. So I was able to assimilate into this. I'm looking out, assimilate into this new area that I moved to that I knew nobody. Oh, here's Philip updating us, telling us. You know what, Mark? Before I get to Philip, Mark says, when you come to Vegas, let me buy you a drink. That's one of the best things to say to somebody because you want to go to Vegas. The word Vegas, I used to go to Vegas 3 or 4 times a year. I didn't have a problem. I had a problem with not being in Vegas. So I'd go to Vegas 3 or 4 times. I just loved it. I would sit in my chair, go in the back of the blackjack table and go, I made it. And for 3 days, I was in heaven. Free booze. I didn't smoke, but I smoked because they gave them for free coffee. And sometimes we stayed for hours and you made friends like a pickleball court. And then at the end of the 3 days, you don't know these people anymore. But Vegas is one of those places. It's a melting pot of friendship. You meet some nice people. So be careful what you ask for. I'm going to hold you to that. My girlfriend and I, she's never been to Vegas. And it's the last time I was out there, I think I was getting stoned just on the contact high. But as I getting older, I've got to go to a different kind of hotel. Otherwise I party my ass off and I can't be and I did this. I can't be on the tables 12 hours a day trying to get my comps, all the stupid stuff. If you're in Vegas, you probably don't play or you're at local places, but I will say yes to that. By the way, as a survivor of divorce, if you will, and bad choices, mostly my bad choices, my number one thing I must give you advice on is say yes. I don't say the N and the O word to anything, and it has served me well. That's just a little advice. I say yes to everything. The only thing I say no to is somebody wants me to do a case that's going to drag me down and take away from my rule, which is work hard, play hard. I won't take the case. And I never used to turn any case down. And I almost was in financial ruin because I just would go with my heart rather than my wallet. But you got to make the money to be so now I can contribute and yada, yada to my religious issues, that place. Oh, thank you. I am going to do that. But I want to get back to something. Mark is a 35-year resident of Vegas. See, that's a true Vegas person. Philip says, I'm not an attorney. Just tell you what Philip Hanley does. I am 77, had a law firm and hired attorneys, retired, but have many family members, but need help. I want to quit when I'm 70. So I'm on a mission to quit when I'm 70, but I thought that way I'd have nothing left at 60 and I've got more than I've ever had. And what's happened is I'm quick, but now I'm not as quick. But then when I get to I've thought of 6 different things, whereas it used to be, and this is a lesson here where you ask me a thing, I go boom, 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 boom. Now I'm not as quick, but at that interim, I think of other things and other ways and so I like the aging process so far. Am I going to be able to do this at 70? I really eat the right food and work out and all that. And by the way, I'm not necessarily a fan of eating the right food and working out. But I have high blood pressure. So that's one of the reasons I do that. And it's probably because of this job. You can see I can't stop. So suck the marrow out of me for advice as long as you can, because I may drop down at any moment. I second that motion on behalf of Mary, Your Honor. Yeah, I really like what Philip is saying. He's now not an attorney. He had the law firm, hired attorneys. So, Philip, is it okay to ask what you do now? You don't. It doesn't mean anything if you don't. We're getting, time is it? It's over 6. If you want to keep going, go a little bit longer. Does anybody else have any? Ask. I don't like not helping, and I don't want to keep talking about myself. Anything that's bothering you about your process or litigation or case, or go ahead and ask. 4 years, Vegas. You know, when I was in Army, they had what's called a dream sheet. I know you know what I mean. So they go, hey, give the 3 places where you want to go. And it's a dream sheet because you're in your dreams. So everybody go, Hawaii. Well, that ain't as great as you think it is. It is great, but I think, Mary, I don't know if you believe me, or it's called rock fever. Hawaii's great, but I gotta get out. I gotta go back to the mainland. It's beautiful, it's lovely, but it ain't all that you think it is to be stuck there for your whole enlistment. So the thing I didn't want, I got. So 2 years in freezing Germany, and it was dirty. And no, Germany is great, but they put you in the field, and I was infantry, so I did some stuff that. Anyway, I was glad to get out. I got my GI Bill, and I was able to pay for law school. So I like the military option as far as public service and presenting people with choices. I think it's a great medium as far as this whole waiver of student loans, which I'm totally for. Wish somebody waived mine. But asking people to perform public service or army is also a nice approach. Jillian, mother 3 from New Jersey. Oh yeah, what exit? You like that? My girlfriend's from New Jersey. She's up there right now. I wish I knew the name of the town, but she has a little house there, and the city, it's close to Manhattan, says we're going to put a ferry port there, which is just, you know what the prices of everything's going to go now. Everybody's rushing in there to buy property. So yeah, she's up in New Jersey right now. Do you have a video on consent orders or pocket orders? Yeah, you've heard me talk about pocket orders. I'm glad you asked that, because that's one of my fun things to give clients. They've made a deal, they've settled, they're going to be making these monthly payments. And then I say to them, I'm going to turn this into a pocket order. And I go, what? And the pocket order is you agree to settle. So the other side is going to give you that settlement, but you're going to face a larger judgment quickly if you miss a payment. So I always say to the other side, hey, do you really want this on the court record that you're settling cases? And they go, what do you mean? Make it a pocket judgment. It stays in the pocket as long as the client follows the payment plan. And then you just dismiss with prejudice with no record of the settlement on the court record. And the debt collectors go, well, that's great. My client would love that. And of course, my client would love that. And that's a nice bonus as someone that's paid me to work their case, to add that they weren't expecting. It's just nice to have things like that. So that's a pocket order. But yeah, even though I just did that in verbally, I will. Hawaii's making us miss Las Vegas. Get a load of Richie Rich. Vegas, they're traveling in areas that I can't afford to do either one for very long. Guess they're paying a lot of money in the Army. They are, especially if you got a couple and you got 2 incomes. Woo! But I understand Hawaii is expensive. So that's a great video that I'm going to do. So my next video will be on consent orders and pocket orders. And it will either be in the vein of the 5-minute interviews where I add paperwork, not interviews, 5-minute videos where I go, hey, this is proof of service. I want to tell you of a good get, and then maybe I'll sign off unless you have questions. You hear me talking about Green versus PRA. I am now trying to find her, and I think it might be easy. And I'm going to try and interview her and do one of these so you get to see how she did it. She's pro per. My research has found her to be in some articles helping the community and helping build houses, blah, blah, blah. So she's appears to be a nice person and knows her stuff. without having to go to law school. And that's my thing. You guys can do this. I'm helping you, but ultimately it's your brain. And I'm giving you the bicycle, but you get there with the power. But I'm going to try and interview Miss Green. I'm going to try and grab a hold of her and then put it online. So maybe I'll do it like this, and then you all can ask questions. That's a big get if I can do that. Yeah, I'm going to do that. All right. If anybody has no more questions, I'm going to sign off. I'm going to sing a song. Just kidding. So I want to thank you. I hope I answered your FDCPA questions. If you have any more, I'm not sure who I was talking to as far as the follow-up as to the validation. I'm scrolling right now. Wasn't good guy Jeff. All right, Mary. Yep. So Mary E, if you want to email me, I'll write the letter really quickly while I sit here and send it to you that I want for a follow-up to validation. You know, that's a video too. What happens when they say they're validating and they send you BS? Well, got to send them a letter. I think I'll create a letter because that's what I do. I give it to my client to. So, Mary, go ahead and email me if you want me to write that letter. And anybody else that wants that, I will CC you on it or send it to you individually, depending on what's up with Mary, if she wants that. But I'm happy to write that letter. The follow-up to the validation, that's another video, because that's really huge. I'll tell you why real quick, because if they keep collecting and they didn't, because that's a BS move. I validated and she didn't complain about. So complain about the validation. You get an FCRA case against them and an FDCPA case. And I'll put that right in the letter saying, you know, if you don't and you attack and you go after my credit and you don't and you continue to collect, that's a violation of FDCPA and FCRA, cease and desist. So they cannot claim that they're not on notice. We work this way through together. So can we leave our email here? Yeah, as long as it stays, meaning, sure. I just don't want to lose it when how could I do better? Would it be easy if I just write my email in the comment section? It should be good. All right. Brian Parker at collectionstopper.com. So I'm signing off now. I'll do this again in a couple of weeks. I probably should have advertised it better to get more questions, but this was lovely. Like someone said, we should have had a beer together. So I will say adieu, goodbye. Let's keep this in Vegas and see y'all soon. And you can contact me with questions, etc. All right. Thank you very, very much. It's an honor. And we'll talk later. Bye now.